guys, it is about 8:32, Monday, December the 14th, 2020. This is week number 6. This is it. It's all over by Friday. This Friday the 18th, and we'll be done. And I told you guys it'd be a quick uh, 5.5 or roughly close to 6 weeks, and this course would be over. You know, it's been really interesting what's been going on. You guys remember that at the week 1 when we had the issue or the question about the Supreme Court justices being appointed for life. You remember that one? Yeah. And I made some comments during that period about how why they are for life so that they would not be able to be interfered with in terms of their decisions and that they would not owe anybody anything. Well, you saw what happened this past week, not once, but twice, with the United States Supreme Court involving um, Mr. Trump and uh, individuals who wanted to bring actions to try to overturn the election, including that ridiculous Texas lawsuit. I say ridiculous because I'm a professional. I looked at many of those briefs and I looked at them and I just shook my head and just said, there's no way. But you know, um, it is unfortunate people don't understand that when they appoint someone to a position like the Supreme Court, that it's for life, that they're not going to be able to control them. And that would be a bad, bad, bad thing. If the Supreme, and the way that the Supreme Court handled it, they hit it on the issue that I said from very beginning when I was talking to all of my friends this past week, knowing constitutional law as I do from college when I took my political science, constitutional law, to law school and the years of practicing, that standing, you got to have standing in order to be able to bring an action. That means you have to have a vested interest. And there is no way in the world that uh, the Supreme Court would allow one state to tell another state how to run their elections. We'd be in big trouble if that happened, and it would violate the Constitution, Article 3. It would interfere with the 10th Amendment and all of those different things. So, uh, you guys had a chance to see constitutional law in action um, this past week. And the Supreme Court, though I know that they're going to come down with some decisions that I don't like, but there was no way in the world I could see that they would come back with any other way. It was unanimous, even though in this last decision, justices, I think it was Alito and Thomas said that they wouldn't even, no, that they would allow the suit. This is what they said. They said, we'll allow you to file the suit in the Supreme Court, but we'll give no further relief after that. That was basically a way of saying you could file it, but we're not going to hear it, or we're not going to do anything after that. So, yeah, I thought it was kind of funny too. But so that wasn't a dissent. That wasn't even a concurring. That was unanimous decision. That was just their side remarks. And if you read the one or two paragraph statement that they included in there, they basically included information saying that there was no merit to the case. But if you took the time to read the briefs, oh man, there were a lot of them. And then I was very, 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 very shocked when these 25 U.S. congressmen and one senator joined in by signing on. But you know what? I'm going to tell you something that I learned in law school that, and it really was true, that when you practice law, if you bring what we call frivolous lawsuits, and God knows that there were many frivolous lawsuits brought before it reached the Supreme Court, that when you bring a frivolous lawsuit, there are these things called sanctions. And I have seen some of my colleagues get hit with sanctions for bringing frivolous lawsuits. And the least of them were at least to be held responsible for the attorney fees of the other party for bringing such a lawsuit. And all of those cases are 51 to 1 that were filed. And then they kept saying, we want to get to the Supreme Court. Well, they made it. And then after that, then the president got mad at the Supreme Court. He got mad at his attorney general for saying that he in the Justice Department, that there was no fraud found. They did complete research. He didn't want to hear that. So, you know, it's remind me of Rumpelstiltskin. Do you remember Rumpelstiltskin? Do you remember Rebecca Rumpelstiltskin? Yeah, and Rumpelstiltskin just kept stomping and stomping, and that's the way that that he's going. And now they're going to go with one more thing. They're going to try on the 6th of January to put a fight up in the Senate. This is unheard of. This has never happened before. Okay, I'm old enough to go back to elections that involve Richard Nixon and Eisenhower as a little bitty kid. But Nixon, I remember extremely well, and all the other elections. I remember Bush v. Gore about the hanging Chad case down in Florida. But even the loser there, Al Gore, said, "Okay, I accept the decision." But this man, he's just not hearing it. And so anyway, we'll see what happens. He says he's going to run in 4 more years. I would honestly say that I don't think that's going to happen. And if he does, the Republican Party is going to be equal to the Titanic. It already is equal to the Titanic. And then I don't know if you guys heard today that one of the congressmen from Michigan, a Republican, a staunch Republican, I saw him on CNN and he was being interviewed, and he said that he was submitting his resignation from the Republican Party because he said he doesn't recognize them anymore. So it's you know, the key thing is this: whatever your politics are, you know what has to come first before your politics? Country. And right now, I am really sad in my spirit, in my heart, that this guy has torn the country apart. It's almost like I wasn't alive, but I read about it during the Civil War with the North against the South. And then think about it, guys. If you are a elector and you had to vote, and in particular if you were a Biden Harris elector, your life was threatened. Come on. 4 years ago, Trump won. I didn't see people going around doing that, you know. But this is going too far. This is way too far, and I didn't get a chance to listen to the president-elect's speech tonight. I will hear it a little later, but I just had to say this to start in this class because there are so many issues involved that fit within the realm of us as uh, people who believe that we should respect the letter of the law. If we're in criminal justice operating and begin to understand that, you know, if we don't have law and we don't abide by the law and the rule of the law in a democracy, you know, then we're in trouble. We're just like Russia and some of those other countries, uh, China, you know, uh, was it North Korea? I mean, it's just terrible. And in my whole lifetime, I have uh, I've seen some of this stuff happen before, but I thought that we were in a different era. But now it seems like I'm just concerned. I saw someone I know making jokes about Biden and Harris being persons of the year, co-persons of the year, saying that they could share the Nobel Peace Prize, and I laugh out loud. This is terrible. This is crazy. So anyway, that's what I wanted to say. But I'm telling you guys, this has been a very interesting period to be studying constitutional law. That is for sure. So let me get into sharing my screen. This week, you um, really don't have a whole lot of stuff that you're going to be doing. Um, you'll see down here, you get to week 6. You're going to write about the death penalty in your written assignment and describe how the death penalty fits into the Constitution. And you're going to discover that um, the death penalty is constitutional. It was ruled to be unconstitutional um, at one point in 1972, but then it was said that the Constitution, that death penalty uh, with certain standards was not cruel and unusual punishment. And we'll talk about that a little bit tonight. So you're going to anyway describe if the death penalty fits into the Constitution and answers under the law. Is it fair? Do you know the amendment off the top of your head that applies to this? You know which amendment of the Constitution? That's to the states. But there's an amendment that applies directly to cruel and unusual punishment. That's the right to remain silent and self-incrimination. One more shot. It's the Eighth Amendment. It's the Eighth Amendment. You got to have the Eighth Amendment in there. Eighth Amendment is the constitutional provision. Yes. Yeah, not the fifth, not the sixth. The 14th applies the Eighth Amendment to the states. Yep. Yeah, yes. Yep. So yeah, it's the Eighth Amendment of the Constitution, which talks about that, and we'll talk about that in the lecture. So you're going to explain why and so forth. So you're going to do a paper, and then I'm going to talk a little bit more about it in a minute. And then your final project. You're going to turn in your final project. So this you should already have ready because of the fact that you're going to focus on the aspect that you use of the Fourth Amendment in the area that you decided, include relevant state secondary sources and case law, which you should already have by now from previous weeks. Recent case, you should have that from a previous assignment. And then you would have optional the interview with a local law and professional. I think, Rebecca, you did the interview, didn't you? I think you did the interview instead of the alternate assignment. Didn't you do the interview? Oh, remember what I said? Do you remember what I said about that? Remember what I said? Yes, I did. Excuse me. That's why we did that. Is because we knew that students were going to run into that problem. And even though you had two sources, I think, but yes. So anyway, I haven't graded the fifth week, week 5. I will be in the next day or two. But anyway, the point of the matter is that yeah. So you don't have to worry about including that in your final. That's why I put it in as optional. I added that to the rubric. They didn't tell me to do. I added that to it because the fact that uh, because of the alternate assignment for week 5. Okay, and then of course, my video, adversity springboard success. So anyway, this is it. The last lecture. It'll be posted here for those who are not here. And then let's look at the calendar. All right, here we are. You see it right here. Your reading assignment, which I sent you the PowerPoints for 12 and 13. And then your initial post due tomorrow night involving DNA. I already, oh, and okay, never mind. Wait till we get to the assignment. Wait till we get over there. And then your reply post is due instead of Saturday. Everything is due on the 18th. That includes your reply post, your written assignment, your final exam, and this. So I said that you didn't have much to do. Kind of, sort of, you really don't, because the death penalty one is pretty straightforward. Your final paper, you should have been building upon that from the very first week that we had. Yeah, yeah, it doesn't take long to do the which one? Oh, the death penalty one. Okay, and yeah, that was pretty easy to finish. And then the other should be not too difficult because you were building upon that starting from week 2 when you chose your topic. So that should be pretty easy because you really have done the work by then, including briefing those cases. Yep, that's what I was talking about. Most of the work is done. So then you just have to do the final exam. Okay. And then of course, your reply post to the DNA. And that is it. So everybody should remember, if it comes in on the 19th and after, all deals are off. I can't accept it. So all assignments have to be in by Friday. So let's go and take a look at the assignments for this week in detail. So in your final project, it kind of already just basically says what I just said a few minutes ago. However, one of the things that it did not say in there was the length of this paper. Should be easy for you to do the 6 to 8 pages because you already have the research and the material, utilizing your cases that you briefed and the recent case that you did a few weeks ago. Make sure you have APA set up and double space, not single space. Again, like I say, uh, interview with a local law professional. Remember, that's optional, and that's only if you did it. If you didn't, don't worry about it. Just deal with all these other points. Notice it should be familiar. your selected area of the Fourth Amendment. That's week 2. Opinion of the law in your chosen area and current state, what changes you would make and why. Include relevant case law and secondary sources. Recent case, you should have done that already, and then you don't have to do that. So the key thing is you want to be able to elaborate on what you completed in those weeks, and then just submit it. Remember, 6 to 8 pages. Okay. Your written assignment, death penalty, 1 to 2 pages. And I already covered these issues as well. Okay. And we're going to cover it in the lecture when I talk about the death penalty in just a few minutes. DNA evidence. Now, here's what I was going to tell you. Now, for the initial post and reply post dealing with Juan Rivera. Juan Rivera was a case that I'm familiar with from Illinois. Actually, both are. But Juan Rivera has to do with Northwestern, my alma mater, wrongful conviction. And review these cases in detail for the exoneration. I said this before, and I said this many times in all of my classes, that one of the most revolutionary tools in criminal justice that came along was DNA. It was not there when I started in '78. In fact, it became useful near the period when I was nearly ready to retire. It came in the late '90s, and I retired in 2000. And it's been used quite a bit since that time to exonerate individuals. It's also been used to identify individuals, identify bodies, but it's also been used to convict individuals. You are from Illinois, Rebecca. You remember the Brown's chicken murder up in Palatine? Yeah. Well, DNA evidence is what a combination of DNA evidence and the person speaking about what happened that resulted in the conviction of the individuals. Because what they did was the ultimate thing that created the evidence to be able to bring it to a head was the night that the killings took place. The individuals who committed the offense ate chicken and left some of the chicken there. And so their DNA was in the chicken that they had bit, and it was preserved and saved. And that's it. So DNA solved that one. Yeah. I believe that one day DNA is going to solve the killing that took place in Tinley Park. You remember the murder in Tinley Park at the what was the name of the store? Was it Lane Bryant in the mall in Tinley Park? Do you remember that? Yeah, yeah, it happened. Oh God, it happened. Oh, I want to say about 10 years ago, something like that, 8 to 10 years ago. In the mall there in Tinley Park, there's a mall right off of I-80 in Harlem. And I think it was Lane Bryant. It was one of those female clothing stores. And anyway, I believe that one day, and they have a picture that floats around of an individual that's a suspect. And so those crimes get solved more now with DNA. But DNA is good. So anyway, what I was going to say about Juan Ferrer and Jerry Hobbs, I provided in my post for this some information that can help you. because I don't know if you tried the links yet, but getting into, okay, then we have, before I get to that, we got the final exam. It's going to be 19 multiple choice and true false questions with 6 short answer questions. Please do me a favor. This is closed book. Do not have your books open. There are students who have given themselves away because they've copied and pasted answers. I could tell, not so good, and they lost points. And it was actually a violation of the academic misconduct policy. Answer the questions. Provide all of the details, but you got to make sure that you understand and study. There's 6 short answer questions. I will be answering those manually because I know what goes in there, and I will have to answer for each of your papers. The multiple choice and true false questions I won't, but the 6 short answer questions I will. But you've got to know different things. You've got to understand Miranda warnings. You've got to understand some other things. That's the only one I'm going to comment about. But there are several other important issues and cases that are very important about such as the right, what bail is all about. That's the last thing I'm going to say, because I've already given you 2 points that are on here, and there's only 6 questions. So anyway, I'm not giving you the answers, but you got to be able to answer those questions. And there are some more questions involved that you should be able to answer quite easily. And so how do you study for this? The way that I tell students is, if you've done the material that you've done weeks 1 to 5, you're ready already. You're ready. You're already ready. If you paid attention to the lectures, you're ready, and you should do well with the test. And remember, it's a time. It's for an hour. And then your live classroom lecture. All right. So now let's get to the week, crime and punishment. All right. So we're going to discuss cruel, unusual punishment. That's pretty much what we're going to talk about. Cruel, unusual punishment. And under that, we're going to talk about some other things too. All right. We're going to talk about DNA evidence and so forth. And so right off the bat, it tells you the article or the amendment that's involved. And it gives a case, a 2012 case relating to the 8th Amendment. And the whole question of cruel and unusual punishment, though, was given in the, here we go. I'm going to give you the exact site. So give me a second. Here we go. Furman v. Georgia. Furman versus Georgia was a 1972 case. By a 5-4 decision, the Supreme Court invalidated the death penalty. Said it was a violation of the 8th Amendment in a 5-4 decision. That was decided in 1972. However, they turned around in 1976, 4 years later, in Gregg versus Georgia. Again, the citation for Furman versus Georgia is 408 U.S. 238. But in Gregg versus Georgia, which is 428 U.S. 153, a 1976 case, they said that the death penalty could come back under certain standards. And so that is why at the present time, the death penalty takes a long time in order for a person to be executed. It takes many, many years because there are many, 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 many procedural steps. In fact, there is what we call a bifurcated hearing, where the person, if they qualify for a crime that has the death penalty, then that individual find themselves in the situation where they are then determined if they're found guilty. Then a second hearing is determined by a judge or a jury whether or not that individual is going to be held to the death penalty and executed. Now, and it takes many years because the governor of many states have the right to commute the death penalty and or to pardon an individual before the death penalty. Just recently, there was a young man, I can't think of his name, who was executed um, in the death penalty because the Supreme Court refused to hear the case. But one of the key things that you should be aware of is that we don't execute juveniles. Um, Individuals that are under the age of 18, under the Supreme Court decision Roper v. Simmons, and that's in here, 543 U.S. 551 205. We don't, because of the theory that we utilize in terms of juveniles. We want to try to rehabilitate those individuals. So then Graham versus Florida, looking at that one, they give a citation here that is, it says 130 Supreme Court 211 is a case that actually 2010 is a case where if you look at that citation is the West citation. That's not the official U.S. Supreme Court decision, citation rather. But the court said it's unconstitutional and a violation of the Eighth Amendment to sentence a minor without parole for crimes other than for murder. So you can't even sentence a individual to life that's a juvenile except if it's murder involved. And the reasoning is because of what I said a few minutes ago. We want to try to salvage young people. So going back to the Miller case, which raised the question about the Eighth Amendment, can a person who is under 14 be sentenced to life without possible parole? Well, that was it's quite clear that it is a violation of the Eighth Amendment of the Constitution. So using Roper and Graham versus Florida, the answer is you can't execute juveniles and you cannot sentence them to life unless it's murder. Okay. So that's the standard that we're operating under right now. But the overall issue of the Eighth Amendment of the Constitution, that if you click on this, you should be able to see the Eighth Amendment. Some of these links haven't been working in very well in this class. They're getting ready to try to fix them, I was told, but I hear it's going to pop up here. Yeah, here it is. Excessive bail shall not be required, nor excessive fine imposed, nor cruel, unusual punishment inflicted. And what that basically has to do with is that the death penalty was considered as not being cruel. By the way, many jurisdictions did away with the death penalty. Do you know if Illinois has a death penalty, Rebecca? I know the answer to it, but do you know? Yes, they did. They abolished it in 2011. Yeah. Where'd you hear that at, or where'd you learn that? Did you hear that in this class? Yeah. Do you know how it happened? Do you know who did it? Oh, yeah. Yeah. Pat Quinn. That's one of my buddies, for real. Um, Pat is also a graduate of Northwest University School of Law. And, he became governor after um, Blagojevich got in trouble. Uh, so, yeah, I think it was after Blagojevich, or was it Ryan? Was it Ryan or Blagojevich? Yeah, well, yeah, Ryan was before Quinn. Yeah, so it was Ryan. Yeah, it was Ryan who got in trouble. But anyway, the truth of the matter is that I think though that wasn't Pat Quinn, the lieutenant governor with Blagojevich, and then when Blagojevich went down, then Pat became the governor. I think that's what happened. And so anyway, um, Pat Quinn and I know each other from yeah, Northwestern. Yeah, I'm biased about them. Not only are they a good law school, they got a pretty good football team too. So, but if you on Facebook with me, you see that my position on that. So, but anyway, uh, Pat graduated in the class of '80 from Northwestern. I graduated in the class of '78. And when Pat came in, I was a senior law student, and they assigned us to different law students. And Pat was in the group that I was over. And so Pat and I got to know each other pretty well. So Pat's a real nice guy. I liked him a whole lot. Unfortunately, his battles were the same battles that are taking place now with the Blagojevich. I mean, not Blagojevich, but with Madigan. But Madigan's got his own issues now. But the point of the matter is that, yeah, Pat, it was Pat. He wrote a one-liner abolishing the death penalty. Now, do you did you know that prior to him, under George Ryan, when George Ryan was the governor of Illinois, George Ryan suspended and commuted all individuals on death row to life sentences. And the reason why he did that was, yep, it was 167 of them. You're on it. And the reason he did that was because Northwestern University was one of the big reasons for that. You know that, right? The wrongful conviction project. And because of that, um, it was determined that not one, we used to always say one is too many people that are innocent to be executed. And so as a result of that, um, then it was actually he that got it started. And actually, to be honest with you, I liked Ryan. George Ryan was it's from Kankakee. You knew that, right? Down in Kankakee. Did you know that? Oh, okay. Bourbonus. Called it Bourbonnais, or they used to call it Bear Bonus because the Bears had their training camp there. for the summers for a while at Olivet Nazarene. Yep, yep. Yep, I know all about that. I knew people who were heavily involved in that. So, but at any rate, he was a pharmacist. That's what he was. Then he became the Secretary of State, and then he got in trouble. Remember the Secretary of State problem that created for him was when there was a pastor's family who were killed in a real bad accident, and that opened up a scandal in the Secretary of State's office, and that's what took him down. But I told somebody there was some other issues involved there that people didn't appreciate the way he did the death penalty, commuting those individuals. So he kind of had that. I kind of was unhappy about the way they did him because his wife died and they wouldn't let him out to go to her funeral, and it was just it was anyway. This is a little digression, but the point of the matter is all this centers around the death penalty. They were all parties involved in that. George Ryan, Pat Quinn, were all involved with that. So, but yes, a one-liner, and he said no more, no more death penalty. I remember I had just started teaching at Rasmussen College when that happened. So I was trying to get Pat to come to speak to my class, but um, we kept having a clash in the schedule. So anyway, so the Eighth Amendment, so you clearly get what's happening with the Eighth Amendment. Um, I'll tell you this: you need to know about the Eighth Amendment. That's all I'm gonna tell you. You'll see why later, and I can't tell you why, but you can figure it out. So now let's talk about DNA evidence and exonerations. I've already kind of talked about that. One of the most revolutionary tools that came along when I was teaching criminal law, I talked about this, was DNA evidence and how DNA evidence exonerated so many individuals. Um, and in terms of wrongful convictions, one of the great and earliest of the wrongful conviction cases in Illinois involved a young man by the name of Rolando Cruz. Do you remember the Cruz case? You ever hear about that one? Yes. And actually, that case, I knew a whole lot about that one because that happened in DuPage County and in Wheaton. In fact, the case was tried at the old courthouse, the old Wheaton courthouse, which is across the street from Margiano's now, near Roosevelt Road, where Naperville Road comes together there. And it's now it was closed down because they built the big judicial center on County Farm Road. But the case was tried there, and I got to know the prosecution real well. A guy by the name of Brian Lander, I got to know him pretty well. And so anyway, I learned a lot about that. But what happened is that um, he was charged, Rolando Cruz was charged and actually convicted of the death and murder of a young girl by the name of Janine Nicarico, and that he was held in custody so many years that the Northwestern University School of Law wrongful conviction, that particular program came after I left law school, but it was in the making because we had, when I was in law school, what we called the legal clinic headed by Tom Garrity. And anyway, the wrongful conviction evolved out of that. And so the Rolando Cruz case, they discovered with all of their research that he didn't commit the offense. using DNA evidence, and a guy by the name of Brian Dugan, who was already in custody on other crimes, had committed that offense. So that was one of the earlier cases. And since then, they had many, many, many more. They had a whole series of them. And um, so we talked about the death penalty being cruel and unusual punishment. The DNA evidence exonerated some of these people before um, the time came for individuals to be executed, or some of those individuals who remained on um, in penitentiary for life sentences when the death penalty was done away with in 2011. And so, anyway, we find ourselves dealing with the cases of Juan Rivera. Now, Juan Rivera was a case that if you clicked on this link, it's not going to work. At least mine didn't work. And so what I did was, in the discussion forum, I put two links in there. I put a link to help you with Ron Rivera, and then I put a link in there to help you with Jerry Hobbs. Both of these were Illinois-related cases. This one pretty much involved the Northwestern University. This one involved a young lady by the name of Kathleen Zellner. Have you ever heard her name? Yes, yes. She's tough. And I think she was the one that represented uh, Jerry Hobbs. Um, and but the public defender's office also was involved in it. And I think Kathleen Zellner was involved. And I think this was her case as well. But anyway, I put a link in there so that you can utilize that information. But Juan, it says, as a match in this case, prosecutors would not dismiss the charge against him. And he was convicted on 3 separate occasions. Finally, the appellate court reversed, dismissed the case, and he was able to walk away a free man. Now, what's most interesting, guys, about this is that there have been instances where DNA evidence has been sufficiently brought to establish the innocence of an individual, and the prosecutor will not dismiss the case. And it baffles me, because the scientific evidence that even with their experts still, you know, could not. It's just like mixing up my fingerprints with somebody else's fingerprints. Each of us, you can look at our hands, but when I was in the police academy, we studied this, that each print is different. Everybody's print is different, and that it's hard to get rid of prints. The late John Dillinger, the FBI caught him, and you know what he tried to do with his fingerprints? Do you know? He tried to burn them. He tried to burn them off. He really did, but he wasn't successful. He thought if he burned the fingerprints, that's why burglars wear gloves. That's why the famous O.J. Simpson case involved gloves. And so everybody believes that when you wear gloves, that they can't tell your prints. Well, that's a true statement. But what I'm saying to you is that your prints, and then also one other thing about your fingerprints. Did you not know that your fingernails themselves can be used as evidence, and that there have been instances where individuals, for example, have either been murdered or raped, and they found the skin of the individual under the nails of individuals, and through DNA, they determined that the individual um, committed an offense. So it's a very powerful thing, but it's a very, very, very dynamite tool. There's a guy I know. His name is what is his name? I'm drawing a blank on him. Um, he's my friend in He's in New York now. Uh, Attorney. What is his name? I can't think of his. I know his name, but I can't think of it. I'm drawing a blank on it. But anyway, this young man was. Oh, okay. I think I just got it. Hold on a second. I'm trying to look at my friend information. Adams. I think his name is Adams. Okay, no, I can't think of his first name. Uh, L. I can't think of his name. But anyway, this young man, I met him, not personally face to face, but we talked on the phone. He ended up being convicted of rape in Wisconsin, and he was able to um, get out of that through the wrongful conviction program in Wisconsin. And so he came back to Illinois, and he ended up going to law school. And now he passed the bar. He went to DePaul or Loyola, one of those two. And then when he graduated, he ended up going to Jarrett. Thank you. Yeah, yeah, that's him. Jarrett Adams. That is, boy, you must have done a lot of research on this stuff, right? Yeah, I couldn't think of his name. Okay, I guess I did. Yeah, I probably, I know I talk about a lot of stuff. And, but yeah, Jared Adams, and he is now an attorney in New York, and he has a wrongful conviction program. So yeah, thanks for reminding me. Boy, I tell you, when you're getting 70 years old, that stuff is in there. But you know what would have happened is that if you hadn't said nothing, then after the recording was over, I would have been later on because I get on my treadmill in here to do some exercise, and it would hit me all of a sudden. That's who it is. But yeah, Jared, and he's my friend on Facebook. But you could Google him, and you'll see that he's in New York, and he's conducting those kinds of cases. So anyway, DNA evidence and exonerations, um, they are very important. Okay. The final thing that I want to talk about is the 14th Amendment. And you have to remember one thing about the 14th Amendment. The 14th Amendment has to do with the Due Process Clause. And what that basically means is that you have uh, to be given an opportunity to a hearing before you can be found guilty. In other words, you're presumed innocent until found guilty. It's a sad thing, though, and in reality, it's actually the other way around. The system says that you're presumed innocent until found guilty, but actually, in practical experiences, it is the opposite. As a defense lawyer, it was not my role to prove that my client uh, didn't do it. It was on the prosecution to prove that he did commit the offense or she committed the offense beyond a reasonable doubt. But in reality, in application, it was the other way around. So the due process clause And Section 1 says all persons born in the United States subject to jurisdiction and citizens of the state where they reside, and no state shall enforce any law or abridge the privileges and immunity of citizens of the United States, nor any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of laws. We've already talked about the equal protection issue, but the due process aspects of it simply means, as it talks about in the 14th Amendment, and it relates to criminal law and procedure, it talks about these two examples that you have a hearing before that. Number one, where it says defendant pleads guilty to burglary and the criminal damage to property is dismissed as part of the plea. A year later, the prosecutor charges the defendant with the same criminal charge that was dismissed under the laws of due process. Well, the state cannot re-prosecute this charge. This is not double jeopardy, though, because it never attached since the individual was dismissed. So the key thing is that due process means that it ought to be fair under the law, that you ought to have the opportunity. That's what we call procedural due process. Procedural due process is when you have the right to face your accusers, a right to evidence that they have in writing submitted to you. We have a process in criminal cases called discovery. You know about that, Rebecca, don't you? I know you do as a paralegal. And so that's where we request, it's funny. Did you see My Cousin Vinny, the movie? Did you see that? Yeah. You remember in the movie that he didn't know that he could get the files from the prosecutor, and he was just talking to the prosecutor out on a hunting trip, and he said, "I'd like to take a look at your files." And then he calls his secretary and tells the secretary to give it to him. And then he gets back to the hotel and he's telling Marissa Tomei, who's his sharp girlfriend, that she said, "It's in this book. You're supposed to be able to get it. It's called disclosure." Well, some jurisdictions call it disclosure. We call it discovery, but it's the same thing, where you have a right to, find out what evidence that the parties have against you. So when we first start a criminal case, we have a boilerplate motion that the public defender's office put together for us young lawyers when we first come out of law school, and we utilized that, and then we added our stuff to it. But it was very comprehensive, and we utilized that, and you'd file that early in your case, and then the prosecution had to provide that information, and any information that they withheld against you that was exculpatory, that could, determine that you really didn't commit the offense. Uh, it could actually, they could either have sanctions issued against them, or uh, it could be appealed, and then that was a basis for reversal. So, but anyway, the point of the matter is that, so that's under procedural due process. And then we talk about laws being very clear, like a lot of the loitering laws were done away with for void for vagueness. That's a doctrine that you may hear or run across. Have you ever heard that term, void for vagueness of a law? Well, void, it means what it says. It means it's void because it's vague. The average person would not know whether or not they were violating the law. Therefore, it violated due process, because you can't prepare a defense for something that doesn't make any sense. It's almost like a ex post facto law. You know what ex post facto law is, right? You know what ex post facto? Yeah. Hmm. If you didn't know, it's a Latin phrase which means after the fact. So it's like you do something, then they pass a law, and then all of a sudden, oh yeah, you did it before the law passed. They can't use that against you, that kind of thing. So anyway, that's all I really have for today. But just remember that uh, due process is one of the key factors in dealing with criminal law, and that's the 14th Amendment. And so be aware that the 14th Amendment was passed to apply the first 10 amendments to the states. 14th Amendment. That's why it says what it says earlier. Uh, it talks about the states and what the states could do other than the federal court. So anyway, says the following video will provide you more insight on how investigators help exonerate Jerry Hobbs. I don't know if this is going to work because I tried to click on these links and they don't work. They don't work. I don't know. They're going to have to take them out. But anyway, if you go to back to what I'd said to discussions and look at the discussion post, you see Professor Wright post, and there it is right there. This is the Juan Rivera one if you click on, and this is the one that involved Hobbs. So you can use those, and then you can find some more on that too as well. So, any questions about anything tonight? Okay, well, as I said at the outset, this has been a very interesting course, especially in light of what's happening. And we do a lot of criminal stuff here, criminal justice, but this constitutional law thing uh, demonstrated quite clearly uh, how important uh, our Supreme Courts are and how important, anyway, our court systems are, period. I am an advocate that oh, I'm glad. Yeah, I don't know how they rhyme this. This course actually used to be for individuals who were studying their bachelor's. Are you studying your bachelor's in criminal justice? Okay, maybe they still do, but they shortened to a 5.5 because I've taught this course. Jerry Lee used to teach it. He's the department chair. Do you know that name, Jerry Lee? You might or might not know him, unless you had him for some classes. He's down in Florida, but he's a retired judge. Yeah, yeah, he's a retired judge. And so anyway, he's the chair for criminal justice, but he used to teach this, but he's teaching fewer and fewer classes now. And so I'm taking over quite a few of the classes that he used to even teach. But constitutional law, I always wanted it because I love constitutional law from the criminal side as well as from the civil side, because it's a very interesting course. And yes, you're right, it would fit perfectly in the um, um, process of people obtaining paralegal training, because a lot of this stuff fits, particularly when you start talking about um, the application of the amendments to the Constitution as well. So, very important. Well, it's been a blast. It's been a pleasure having you, Rebecca, in this class every week. Um, and your other two members of this class, they didn't come, but I know them. Uh, and again, it's been a pleasure. I'm sure that you're going to do well. And then, as you get closer to your movement towards the law school, and then since since this is your choice of schools, you see that, right? You see that? Yes, that's my school. Yay! Go Wildcats. Uh, let's see. I didn't see what that said. It's number one on your list. Yeah. Well, when you get ready to do it, if you need a letter written for you, you know what to do. Just ask me. I'll be happy to write it. Um, I am. I've helped a few people. Yeah. Well, okay. That's good. Study for the LSAT. But I do want to let you know this, and you may know this, or may not. Oh, do you know about um, do you know about the information that I'm getting ready to tell you now? Okay, I'm getting ready to tell you because I've given it to a number of people. Uh, Law LSC. What's it called? Okay, hold a second. LSAT organization. Okay, yeah, I'm getting ready to tell you. It's the okay, yeah. Yeah, yes. Do you know about the, I'm going to type it in here. LSAC.org. Do you know about that? Oh, okay, good. Because they have a whole lot of information. Law School Admission Council, that's what it stands for. And they have a whole bunch of stuff. Every law student that I've worked with, um, they have programs that they can guide and help you to get ready for the LSAT. So I highly need recommend that you uh, follow up with them. But what I'm getting ready to tell you is that you will read and discover about the future of the LSAT is that they're kind of moving away from it and moving more towards the um, graduate, is it the GRE? I think it is. They're moving away from the LSAT. That's not to say that you shouldn't at this time prepare for it. But I can tell you this, that the LSAT is not as heavy on the list of tests at Northwestern. At least it wasn't some years ago. I don't think it is either now, but because there's been some articles written about the LSAT. Uh, excuse me, because I think the LSAT is not a good measure of how successful a person can become in terms of lawyer and getting into law school. Your GPA and other things. When I got ready to apply, I didn't do well with that, but my story about my life that I shared with you guys, I gave it to them in written form as well as I gave it to them orally when I met with them. And and in fact, I don't know if they're still doing it, but they used to call us, some of us alums, and have us to come back to the law school for to interview students. And I interviewed several students. Some got admitted, some didn't get admitted at the law school. Did you not know that the chairman of the board, Dr. Henry Beenan, do you know that name, Dr. Henry Beenan? Have you ever heard that name before? Yeah, he's the chairman of the board of directors of Rasmussen College. He was formerly a president at Northwestern University, not the law school, but the university. And he's the one that issues the award. Kurt got that award a few years ago. And uh, it was Dr. Beanian, in fact, when I found out he was chairman of the board, that led me to decide that I wanted to go to uh, Rasmussen or come to Rasmussen because I had never heard of Rasmussen, but when I saw that he was involved. So it's that Northwestern connection again, once again. So it's the Northwestern people are all over the place. I knew several governors real well. Dan Walker. Did you say you didn't know Dan Walker, right? Oh, okay. Yeah, Dan uh, is a graduate of Northwestern. You knew that, right? That he graduated from, yeah, civil litigation. A lot of people have him for legal writing. He's tough, but Dan he practices in yeah. But you know what? It's okay because that's the way we all are. I'm like that too. Um, we are pretty tough on students, and we try to challenge you. Dan is one of my really good friends on Facebook. So yeah, yeah, Dan Walker. He practices out of Hinsdale. Uh, Dan Walker Jr. He looks just like his dad. In fact, let's see. Oh yeah, here you go. Can can you see that picture right there? Can you see that good? Can you see that? Okay, let me see if I can try to. Now can you see it? That's Dan and that's me. Yeah, that's Dan Walker and me. So, but yeah, really tough. So, well, I'm gonna let you go with these. I know some people are gonna say you didn't give us the key phrase. I said you're right. Yeah, he definitely. But that's what we do. I hope I've done some of that too because I challenge you guys. I make sure that you, like for example, I don't let you get away with uh, things that might seem minor, like citing a case using oyes and justia. I don't like them. I like the original official citations, and I have taken off points for people where they didn't, because I talk about that all the time. I think professionalism is, yeah, yeah, the blue book citations. I take off points because I want people to do things in a professional manner, and that's where I was trained. And so it was tough, but guess what? It was well worth it for me. My life has been good, and I'm able to help students go above and beyond. So anyway, the long and short of it is when you get ready to make that move, you know what to do. Reach back out to me. So I'm going to give you the key phrase that I should have given a while back while we started talking. Eighth Amendment. That's it. So give me Eighth Amendment, and you get all your points for this. Well, it's been a pleasure. I am going to end this session now and say good night to you. And oh, you're welcome. You're welcome. Yeah, definitely keep in touch. I know you're on LinkedIn with me, right? Aren't you on LinkedIn with me? Yeah, I thought so. I thought you were on Facebook too. Yeah. Yeah, I thought we were on both of those. Yeah, so that you can see all the stuff that I'm involved with. Yeah. I'm going to be doing a oh, you use your your maiden name on Facebook though. Okay, but you're my friend on Facebook, right? Yeah. I don't know what I have you under. What do I have you under? What's your maiden name? What is it? Hartley. Oh, okay. Yeah. Okay. Do you know, and I've stopped the recording. Do you know Jill Hartley? Yeah. I don't know why, but that name uh clicks a bell. I think that might have been one of my former students. Yeah, it is. Yeah, Jill Hartley Bannis. Jill Bannis. Do you know that name? Yeah, she's one of my former students. I knew Jill Hartley was, so I didn't know Hartley, Hartley. Is that it? Yeah, well, look on Facebook under Jill Hartley Bannis, and you'll see her. Send her a friend request. Tell her, you're one of my students. Yeah, and in fact, I'm not recording this anymore, so I can say this now. She lives in Manuka. Yeah, that's where Jill lives. Jill's one of my students who graduated, and yeah, she's. I got to follow up with Jill because Jill, matter of fact, you see pictures of us in Facebook there when she graduated. Um, Jill is now seeking to be a probation officer. So, but yeah, check her out, Jill Hartley. I said, wait a minute. Yeah, so Jill Hartley, uh, Bannis. Yeah, she could be one of your family members there. Yep, yeah, yeah. Jim Hartley, Chrissy Hartley, his cousin. She's got all these Hartleys. So I didn't know that you were a Hartley off the top of my head. So, all right. Well, good night again, um, and enjoy the break. Well, what are you taking next? What are you taking next semester or next quarter in the winter? You know? Oh, you know what? I can open up your mic now. If you got a mic, you got a mic? Okay, I opened up your mic.
Hello.
Hello. Okay, so
Hi.
hi. So what else are you taking?
I am taking, let me see. I have them written down somewhere. Okay, I have communication strategies and research methods.
Oh, okay. No, I'm not teaching any of those. Yeah, I'm teaching realities and you ever had realities in criminal justice?
No, this class and crime prevention are my first in my bachelor's program.
Okay.
So,
Realities in criminal justice and critical issues in criminal justice. I'm teaching that in the winter term of one. And I'm teaching that and something else. I'm trying to remember what was the other class. Uh, let's see. I know. Let's see. It's in here. Uh, what does it tell me here? Because I was just looking at it. If it was still here, my Rasmussen stuff disappears. Okay. Yeah, it does. It doesn't stay It doesn't stay in my, okay, let me see. Winter, oh, here it is. Okay, let's see. Yeah, okay, dog, I had it. It just disappeared. Okay, okay, I gotta type it back in again. Winter, winter, winter. Okay, let's see what Andy Benatti is in here. Andy Benatti. Okay, here we go. Let's see. It is, it is, okay, Andy Benatti, and I replied to him. Let's see. I know this is going to irritate me. Let's see. I'll tell you in a second. I'll pull it up on my computer. I know that it's realities in criminal justice and uh, where's my sent items? Here we go. That ain't it. Let's dismiss that. Tentative winner schedule. There we go. Okay. It's contemporary issues in criminal justice. You ever had that?
No, I think they're phasing that one and then the realities
No, what they
course
did
up.
was
No?
no, what they did was they
Hmm.
turned it into a six week. They phased out
Uh,
the 11 weeks. It was 11 weeks before. Yeah, they didn't phase them out
yep.
because that's what's happening. I'm teaching both of those realities of criminal justice and contemporary issues, and then I'm teaching um, introduction to corrections. And
Mm,
then and then and
okay.
then in term two, I know I won't see you drugs and crime and introduction to criminal law because you already had those.
Yep.
So yeah, so that's the stuff I'll be teaching. So all right, well I'll maybe run
Okay.
across you though. Like I said, let me know. You know, hopefully by the time that you get ready to graduate, that they will have graduations again, right?
Yeah, I hope so.
Yeah,
That
yeah.
would be nice.
Yeah, that's what Jill was at the Rialto, the last ones that we
Oh,
had.
okay.
Yeah, have you ever been there?
I have not, but
But
I have been to the courthouse right there, so
yeah, it's right there. Hey, they got a new, don't they have a new
they
courthouse now?
do.
I
Yes,
haven't,
it's huge.
I haven't, you know what? See, man, I'm shelter in place. I haven't even been over that way. I try to go nowhere, you know, but, uh,
Yeah.
but yeah, I knew they were building it. Um, so it's really big. Have you been in it?
Not yet. No, thankfully.
Yeah,
No.
yeah. Because,
I've just
people,
driven past it.
people go in there if they gotta go in there, right?
Yes. I
Well,
only go there now for my divorce,
uh,
when or custody issues now at this point, but that's it. So I'm
yeah,
hopefully won't be there anytime
yeah,
soon.
yeah. I don't know what this is with my students that I have that I teach criminal justice. They have all these custody issues and divorce issues with, and I had to deal with that with several of my students. So, and few of them at the Will County Courthouse. So I told them
Oh,
I,
okay.
but I hear you. I thought you were in
Yeah, yep.
but I thought you were in You're not in Will though, aren't
No,
you?
I no, technically where I live, it's like the border of Will County, Grundy County, and
Okay.
my ex-husband was a resident of Wilmington, so we just filed
Oh,
in. Yeah,
okay.
we just filed there, which honestly, the judges there are better than the ones in Grundy County anyway. So,
Yeah. Well, no, I've been to the court in Grundy County before. My wife had a traffic ticket, and I had, isn't that in Ottawa?
no, it's in Morris. Well, there might be one in Ottawa, but
Okay.
that,
I think there was, oh no, no, it was in Morris. It was in Morris. Was that 47?
yes. Yep.
Yeah, yeah, that was
Yep.
in Morris.
Super
Yeah,
tiny. Yeah.
yeah, that was where I had to go with her. Yeah, yeah, that was Morris. I forgot all about that. I don't know why I thought it was Ottawa, but oh, I know what's in Ottawa. The appellate court is in
Ah, yes,
Ottawa.
yes.
Yeah, that's
Okay.
what I'm
Yep.
thinking of there. So, all right, Rebecca, you have a good
All
one,
right.
and again, let me know if you need anything from me, though.
You too.
All right,
Thank you.
you're welcome. All righty, bye
Bye-bye.
bye.